have the record like this.
इसमें वो जो स्टे एप्लीकेशन लगा हुआ है वो कॉन्स्टिट्यूशन के लिए पेश हो रहा है। हमने मेंशन किया एट माय इंस्टेंस दिस हैज बीन लिस्टेड, दिस हैज बीन लिस्टेड एट माय इंस्टेंस।
Who is the other side? Who is the other side?
तो मनोज कुमार साल नंबर 4 है, उनको हम इन्फॉर्म कर दिए हैं, टेलीफोन ही हैज बीन इन्फॉर्म इन द मॉर्निंग।
रिकॉर्ड आ गया?
रिकॉर्ड तो आया हुआ है, इसलिए चढ़ा भी है, उन्होंने उसको वेरीफाई करके तब उसको चढ़ाया।
क्या मैटर?
इसमें हम लोग ये फाइनल डिग्री का जो है प्रिपरेशन हो रहा था, उसी का स्टे के लिए दरखास्त पड़ा हुआ है और वहाँ पर प्रेसिडेंट वो एक्सक्यूशन में जो फाइनल डिग्री का काफी जो कि के लिए गया पुलिस का बहाली वो मजिस्ट्रेट और पुलिस इसका हो गया है। Therefore it is only for stay.
नहीं
For the time
जब रिकॉर्ड आ गया है तो स्टे के लिए हमने
I am ready to argue the case on merit.
Means
On merit, yes. That is why I want to do it out of terms, irrespective of the fact whether इसमें अपोजिट पार्टी तो कन्वीनियंस फील नहीं करेंगे काहे कि
नहीं ऐसा कुछ नहीं है। आप देखिए आपका टर्न आ ही सकता है, क्या पता।
जैसे देखा जाए काहे कि इसमें
कोई बात नहीं, आप थोड़ा वेट करिए।
हार्डली I shall have to wait. I shall have to wait. तब देखा जाए इसको।
Item number serial number 7, Lordship, although it is listed for orders, the respondent number 1 has died, Lordship, and substitution petition has filed by the appellant. I am appearing for the respondent, Lordship, so I am praying that it may be taken up for the last 4 weeks. It is running under this, Lordship. That's why I am making it clear. छोटा सा काम उसमें
सब्स्टिट्यूशन अलाउ करना है।
हाँ, सब्स्टिट्यूशन अलाउ कर दिया जाए।
कौन है इसका अदर साइड? सीरियल नंबर बताइए।
Serial 7.
Serial 7
FA 37/2020।
उसमें मुझे एक ही बात करना है कि एज ए रूल लॉस एक्सेप्शन में भी अदरवाइज उसमें जब एडमिट हुआ है अपील और स्टे मांगा जा रहा है तो स्टे देना
सर, आप किस केस में बोल रहे हैं? हम सीरियल नंबर 7 से बोल रहे हैं।
I'm sorry, इनका खत्म हो गया उसके बाद।
सर ऐसे नहीं हो सकता है।
Serial number 7.
हाँ, सीरियल नंबर 7।
Lordship, in para 2 it has been stated that she has died, Lordship. Respondent number 1, Dr. Vinita Mees.
आइए नंबर?
IA number, Lordship, 7139. 2022.
You are for the petitioner?
He is for the
Appellant?
appellant, I am for the respondent number 1.
Any objection for substitution?
He has filed it.
We have filed it.
They have filed it. Appellant has filed it. I am for the respondent number 1.
Any objection?
No, sir. I have been furnished in the details of the legal.
You have furnished the details.
Yes,
of the
yes.
legal. You have got the wakalatnama?
Yes, I have received the order. I will file it after allowing this.
IA number 7139 of 2025 in FA number 37 of 2020. The learned counsel for the parties are present. It has been, this petition has been filed for substitution of respondent number 1, who is said to have expired on 15/5/2025. The learned counsel for the respondents has no objection to the prayer for substitution, and he submits that if the substitution is allowed, he shall file. He has already received wakalatnama.
Yes, yes. I
On
have received.
behalf of the proposed legal heirs and successors of respondent number 1, and he shall file the same within a short time. Considering the aforesaid submissions, the prayer for substitution of respondent number 7, respondent number 1 is hereby allowed, and the counsel for the appellant is directed to delete the name of respondent number 1 and insert the name of legal heirs and successors of respondent number 1 as mentioned in paragraph number 2 of the interlocutory application in reading during the course of the day. The Mr. Prabhash Kumar has already undertaken to file wakalatnama. Let it be done within a period of 1 week.
Lordship, may I pray a date be fixed?
Date to हर एक केस का रहता
ठीक.
है. Pose this case on.
Both of us are ready for it.
Yes, yes, both of them.
अब देख रहे हैं ना आप कितना मैटर्स चल रहा
हाँ,
है.
नहीं,
तो उसको खत्म करना जरूरी है.
एकदम it is
Unnecessary pressure लेकर हम काम नहीं
for
कर
your
पाएंगे. There are so many judgments also to be delivered.
एकदम for your lordship.
अभी थोड़ा दिन थोड़ा लाइट काम करेंगे. आपका वो मैटर कर लेंगे. उसके बाद ही
all
करेंगे.
those matters they
ऐसे CAV करके और
नहीं, एकदम.
पेंडिंग पड़ा रहने से
I
कोई
know
फायदा
that.
नहीं है. That does not serve the purpose.
Preparation.
कुछ केसेस में तो टाइम भी एक्सपायर कर चुका है लेकिन still I am working on it. There are certain matters which we have to
whatever is convenient. We just express our readiness to argue.
take. Records have come.
हाँ, records.
With the consent of the counsel for the parties, the matter has been directed to be posted for final disposal on 15th of September.
Yes.
फाइनल डिस्पोजल में आएगा तो कोई भी कोर्ट होगा तो
ठीक ठीक
आइए
Orders with effect acting 2nd to 70 of 2023.
आप लोगों ने अपना रिटन सबमिशंस फाइल किया है कि नहीं?
इसमें
नहीं वो वाला जो सेकंड हाफ में कल सबका
हम सैटरडे को की
अच्छा कोई बात नहीं आपको जरा आपने कर दिया सबका आ गया है उसमें
सहारा भी दे दिया ये दे दिया तो हो गया
हो
सबका
गया
हो गया
जरा उसको भेजें
बिकॉज वी ओनली 3 आर द एक्चुअल कंटेस्टेंट पार्टी
ठीक है आज थोड़ा देख लेते हैं
एकदम तो
यस
This is under orders with defects. There are two defects that are pending. One is that a prayer for stay was to be deleted and an IA for stay was to be filed. Should the prayer for stay has been deleted,
Okay.
the IA would be.
It just says that prayer for stay may be deleted from prayer
Yeah, that
portion.
has been deleted, but it has been marked as partially removed.
Yes, why partially?
They expect that once we have done that in the petition for stay, we have to file an IA.
You may not file an IA.
That is.
Simple. Okay, then
And the second is that the alias name. The name of the appellant has, in one of the name it has double N and in one of the name it's a single N. Leadership, the degree under appeal has double N and the degree under title it's single N. We have used the alias name.
what is the actual name as per the plaint?
As
You have to
per
go
the-
as per the plaint, isn't it?
The degree under title suit was prepared as per the plain, but the degree under appeal, since I was the appellant, has been filed with double N. So we have used both the names.
You can't use alias names like that.
That is the defect.
We will get it corrected. They will verify it from the
Degree under original suit is at page number 56.
you have given double N everywhere, even in
Because-
your wakalatnama.
Yes, because the civil appeal that I filed, I was the appellant and I filed it with double. That's the original spelling. But the suit was filed against me. I was the defendant there. It was filed with single.
You filed with double N. Father's name is the same.
Yes.
Okay. Essay number 70 of 2023. The learned counsel for the appellant has submitted that defect number 1 has been removed by deleting the interim relief in the prayer portion of the memo of appeal. And he submitted that since no separate petition for stay has been filed, therefore it has been stated to have been partially removed. He submits that the surviving defect, if any, in connection with defect number 1 being considering the submissions and the prayer for interim relief having been deleted from the prayer portion, the defect number 1 does not survive. With regard to your file any interlocutory application also?
Not.
What is this?
It's an IA for substitution. The
Okay.
appellant has.
With respect to defect number 2, the learned counsel has submitted that before the learned trial court, the name of the appellant was mentioned as Punallal Sharma, son of late Bajranglal Sharma, and before the appellate court, the appeal was filed as the spelling of Punallal Sharma as Punallal Sharma, son of late Bajranglal Sharma. He submits that with respect to spelling, the defect has been pointed out. The learned counsel submits that such defect may be. Considering the aforesaid submissions, the defect in connection with defect number 2 with regard to alias name of the appellant is ignored. Or the what else?
The IA number 8056 of 2020 has been filed for substitution of the sole appellant who is died during the pendency.
IA number 8056 of 2025 has been filed seeking substitution of the sole respondent, sole appellant, who expired during the pendency of the case on
24 to 2025.
on 24 to 2025. The name of legal heirs and successors has been mentioned in paragraph 4 of the interlocutory application. Considering the aforesaid submissions and the amendment made in the interlocutory application seeking substitution, the interlocutory application is allowed subject to any objection which may be raised by the respondent if ultimately the appeal is admitted and notice is issued upon the respondent. The learned counsel for the appellant is directed to delete the name of the appellant from the cause title and insert the name of legal heirs and successors as mentioned in paragraph 4 of the interlocutory application. Office is directed to place this case for under appropriate heading on next Monday. Yes, ma'am.
Item 2, CMP 154 of 2024.
Sorry? CLP number 154 of 24, it has been reported by the office that this case has been wrongly listed under the heading for orders with defect. Office is directed to place this case under appropriate heading on next Monday.
For admission, item 13, first appeal 101 of 2025.
Is it maintainable against a probate case?
हमारे पास एक ऑर्डर है प्रॉफिट मॉडल कोड का इसी ऑर्डर के राइट पे आइटम फर्स्ट अपील और दूसरे
दोनों एक केस में हम लोग ऑर्डर किए थे, एक केस में हम लोग ऑर्डर किए थे मिसलेनियस अपील में लैंड एंड नॉट फर्स्ट अपील, एक केस में हम लोग ऑर्डर किए हैं। How is this maintainable? You explain us. We cannot leave both the things, either first appeal or miscellaneous appeal. No, there is no decree prepared. You explain. You explain it to us how the first appeal will be maintainable. Yes, how the first appeal is maintainable? Not maintainable.
No, 299 Indian successor है
Miscellaneous appeal will go.
We will convert it into additional member metals.
देखिए FA number 101 of 2025. this appeal has been filed against the judgment dated 10/1/2025 in probate case wherein the probate case has been allowed. It has been allowed.
Yes.
Counsel for the appellant seeks permission to convert this first appeal into miscellaneous appeal and has submitted that the first appeal may not be maintained. Sir, कर दें?
मेरे समझ में हम बस कन्वर्ट करेंगे परमिशन ले वही करते हैं.
Okay, counsel for the is SLK. Counsel for the appellant seeks permission to convert this first appeal into miscellaneous appeal. It will be done by the appellant. फर्स्ट मिसलिनियस अपील लाइक करता है सारे प्रोबेट केस में जितना बिल और ये सब होता है सब में मिसलिनियस अपील लाइक आपको अपना ऑब्जेक्शन रेज कर देना चाहिए ऑफिस ऑब्जेक्शन उसके बाद कोर्ट में जो ऑर्डर होगा होगा
Hearing under order 41 rule 11, item 14, second bill 542 of 2018.
This appeal is directed against the order lawsuit, order dated order and judgment dated lawsuit passed in civil Aviso for 21 of 2012. Lordship, the fact of the case is, Lordship may see just I am explaining the facts of the case. Lordship may see the impugned judgment at page 37. That is the genealogical table which have been formulated and accepted by the appellant and defendant respondent. Page 37. One Kwaleswar Mahto, he had two sons, Lalu Mahto and Jhari Mahto. Lalu Mahto had three sons, Lochan, Paltu and Jagannath Mahto. Lochan and Paltu both died soon, and thereafter from the branch of Lalu Mahto, only Jagannath Mahto was the surviving legal heir and legitimate. Now Lordship, second branch, Jhari Mahto had two sons, Sukan and Ugan. Sukan had died in 1991 and Ugan has legal heirs. Ugan has now died after fighting of this appeal. And Sukan Mahto has four daughters and one son. Fourth daughter, Urmila Devi in Rajesh. The case is that Lordship, the Jagannath Mahto, son of Lalu Mahto, had no issue and his wife has pre-deceased him. So she has taken over Urmila Devi, and Urmila Devi used to look after him during his lifetime, and Jagannath Mahto had executed a deed of gift in favor of the Urmila Devi. Now, the deed of gift was executed on 10/6/99, and after execution of deed of gift, Jagannath Mahto has another notarized one will that the remaining property shall go to the Urmila Devi. It has been heard that Urmila's marriage was solemnized by the Jagannath Mahto, and thereafter Urmila Devi and her husband, they lived like in the house of Jagannath Mahto as Damat, and they looked after the entire property. Now,
so they will not succeed as a successor of Jagannath Mahto, even if they looked after him.
That's the point.
They are governed by customary law.
No, they are governed by the Hindu law.
So Hindu law, they will not inherit even if they have been living on. There is no adoption.
No adoption.
Then
There is no registered adoption.
no, there is no adoption. Did you plead adoption?
They have said that she was adopted by the Jagannath Mahto, but in fact, Lordship, there is no deed of adoption to that effect. But the witness,
Any ceremony performed, adoption has been proved.
the defendant witnesses, they have said that she was adopted by the Jagannath Mahto.
ऐसा नहीं होता, adoption ऐसे नहीं होता.
नहीं, वो तो मैं जानता हूँ कानून में कि सेरेमनी होना चाहिए, गिविंग एंड टेकिंग होना चाहिए.
Adoption is required to be proved.
But
What is the date of death of Jagannath Mehta?
they claim, the plaintiff claim the date of death of the Jagannath Mato is 4/5/99,
Yes.
whereas the date of death of, as per the defendant, that is 4/8/99. That is also point of view. Defendant witnesses, they have said the date of death of the Jagannath Mato is 4th August 99, भादो महीना में इनका देहांत हुआ. So this point has contradictory statement.
Even your witnesses have given contradictory statements.
My 3 witnesses, they have said that Jagannath Mato died in August भादो of 99. But the defendant number 1, Urmila Devi, due to mistake or due to she has said 4/5/99. That is
Therefore, it is a case of Urmila Devi only,
Yes,
as
Lord.
per her evidence, that he died on 4/5/99, which is matching with the case of the plaintiff. Correct? And therefore, Urmila Devi was living with him. She is the best person to say when he died. And this
question-
gift deed is 10/6/99. Will is thereafter. How can you? No, there is
Lordship-
absolutely finding of facts recorded.
Lordship,
And-
in fact, the 3 witnesses, they have said
So what? There is a contradictory evidence.
now Lordship Messi, the plaintiff has claimed that the possession may be declared. Lordship Messi, what is the prayer made?
You see your prayer made in the first appeal. You are only concerned with the gift deed. In the second appeal, this is what you are agreed with. Only against the finding of the learned appellate court, wherein he held that the deed of gift is not enforceable.
Lordship, there
You have to confine it to this only because
there
this
is
is your
serious
only
conflict,
claim.
Lordship. Plaintiff has filed the suit in 99 for declaration that the plaintiff is coming in possession of the suit land, house and trees over the suit land as owner, perfected the right title thereof on the death of Jagannath Mato and impugned deed of gift number 2285 dated 10/6/99 alleged to be executed by Jagannath Mato in favor of the forged, fabricated and void ab initio. But this deed of gift 10/6/99, they have averred in the plaint dossier that he has obtained the certified copy of the deed of gift, but it was not made exhibit during the trial court, before the trial court. Ultimately, the defendant exhibited it during the
First appellate.
in the title appeal, and that will be apparent from Lordship Messi, page 43, Exhibit I.
So,
So my humble submission to that effect, when a person plaintiff is seeking relief for declaration that the deed of gift is void and ab initio and it is not enforceable, he ought to have exhibited it, but it was not exhibited by the plaintiff. Lordship Messi, page 43, last from bottom, I original gift deed, mass and exhibit on page 716 in the appellate court. Defendant has exhibited it. So
Okay.
my humble submission to
but
that.
the finding is that the deed of gift is post.
The finding is that it is not in deed of gift and will is not enforceable. So Lordship, how they have come to the conclusion without
Just a moment. Deed of gift was executed when?
on 27/16 is before the appellate court, Exhibit I.
When was it executed?
Yes, Lordship.
When was it executed? Deed of gift.
It was
Registered deed of gift was executed when?
on 10/6/99.
6/10/99. Right? 6/10/99.
10 है जी.
ये तो प्रेयर में लिखे हैं 6/10/99. इनके प्रेयर में तो 6/10/99 है ना?
Typographical error. Lordship.
टाइपोग्राफिकल एरर किसका टाइपोग्राफिकल एरर हम लोग यहाँ पे चेक
Typographical error that I have seen.
सेकेंड अपील में आपका टाइपोग्राफिकल एरर नहीं देख सकते.
Typographical लेकिन इसमें है.
नहीं ऐसा नहीं होता है. And the deed of and the date of death has not been proved. And rather, your witness has said that she died on a date on 4/5/99.
In fact, there is no clear finding to that effect.
Need not be, but your witness has said that he died on 4/5/99.
Lastly, I am making an honest submission that
Honest
three
submission.
witnesses, 3 defendant witnesses, they have said it.
Maybe
But
it is contradictory evidence of the defendant witness with respect to the date of death. You have not proved the date of death.
In fact, Lordship, the plaintiff has taken a defense that death certificate was issued by the block and it was washed away in the while they were traveling in the train. So it was not yet exhibited. And second point is, Lordship, we may consider that the learned trial court has travelled beyond the prayers made in the plaintiff, Lordship. Lordship, just for a moment, Lordship may see the trial court judgment. What was the prayer made that I have read before your Lordship? But trial court judgment has said it will devolve upon the legal heirs of the Jagannath Mato. Operative part may be seen. Page 30. Page 30, operative part of the trial court judgment. This suit, so far as declaration of gift and will of Urmila favor is concerned, these documents are declared as not enforceable, and so far the right title in possession of plaintiff and defendant are concerned, it is ordered that the property of Jagannath will devolve in favor of legal heirs in proportion to their respective shares. As such, this suit is partly decreed in favor of plaintiff, and the property of Jagannath will devolve in favor of their next legal heirs in proportion to their shares and rights through process alone. So the learned trial court had travelled beyond the prayers made in the writ application, and he has created a third prayer by himself, and he has allowed people to devolve. It was not the prayer of the plaintiff. And thereafter, Lordship, in the trial court, the appeal has been partly allowed. And Lordship, the most important point, Lordship, the issue number 6, which was framed, whether the Ugan and his brother, they were living in unionship, reunion, or separately. That has been decided. They have separated Ugal and Sukan. Defendant number 1, Urmila Devi, is daughter of Sukan, and Ugal were brothers. So these are the admitted facts. The plaintiff and defendants are legal heirs of the Jagannath Mato. So my humble submission to that effect is, since the deed of gift was not made exhibit, it was made exhibit during the course of, during the stage of appellate court, before appellate court. So the substantial question of law, there are two substantial questions of law. The first point is, Lordship, whether exhibit I confer any right upon the defendant number 1, deed of gift, and second, Lordship, whether the learned trial court has travelled beyond the prayers made in the writ application, and moreover, the deed of gift was not exhibited by the plaintiff in the trial court. Although it was in possession of him, he has said he obtained the certified copy after hearing that one deed of gift has been executed in favor of Urmila Devi on 10/6/99. So these are the two substantial views. Lordship may see issue number 6 of the trial court. Issue number 6, page 22. They have said this Sukan and Ugan, they have separated.
Gift it ka copy दिखाइए. The deed number 2285 was never exhibited.
No, it was exhibited during the course of appellate stage on 27/16 by the defendant.
What was exhibit B?
Exhibit with a bill. That was bill.
And gift deed 228599 exhibit E. What was exhibit E? Exhibit E at page number 22.
Yes, Lordship.
How do you say that it was not exhibited? Yes, it has been exhibited before the learned trial court. Exhibit E.
But Lordship may see the judgment.
आप हमको exhibit E बताइए जो ट्रायल कोर्ट में लिखा हो गया।
दिखा देते हैं।
हाँ।
Lordship, just for page 56 may be seen, Lordship. Page 56. Page 56 from bottom 6th line. The original copy of deed of gift has been filed from the defendant side.
वो छोड़ दीजिए ना, ऊपर देखिए ना, exhibit B is the deed of gift, exhibit B/1 is the deed of gift which was notarized by notary such and such. Exhibit E is the certified copy of the registered gift deed. It is mentioned.
हम exhibit ही हम दिखा देते
भाई
हैं।
original कोई produce किया इससे क्या लेना देना है? Registered certified copy of the gift deed was produced before the court. Exhibit E.
In fact, Lordship, there are two documents. One the registered deed of gift and second one notarized the will.
You forget about notarized. Exhibit E was a registered deed of gift.
इसमें differentiate कर रहे हैं, यहाँ पर ऊपर में लिखा है page 56 में exhibit E is the certified copy of the registered gift deed and then they have said original gift deed has been deed of gift in the London workbook has been offered from the defendant side.
Who was claiming? Urmila was the defendant.
Urmila was the defendant number one.
Naturally, if the gift was given to her, the original would not lie with the plaintiff.
Plaintiff had said he had obtained a certified copy of the deed of gift.
Naturally, he will obtain certified copy only. When the property is gifted to Urmila Devi, the original will lie before Urmila Devi only.
Yes,
She would have only produced the gift deed.
She has produced it during the appellate stage
Yes.
on 27/2016.
Fair
Lordship,
enough. It's the same gift deed. There is no difference.
The substantial question of law before your Lordship is whether the deed of gift which was executed by the defendant herself on 27/16 has been properly appreciated by the court.
Need not be. It's the same thing. उसी का certified copy तो
And
file
second point, Lordship, the learned trial court has travelled beyond the prayers made in the writ application, beyond the plaint in the title suit, and the in title appeal, it has been said it is partly allowed. Lordship may see the final operative part of the judgment, page 62. And second point, Lordship.
You see, so far as the direction or saying that it will devolve upon the legal heirs and successors, that is certainly beyond. We can frame a question of law on that, but not on the point of gift deed.
Second point, Lordship.
Gift deed you have not proved.
Just for a moment, the 62, page 62 may be seen. issue number 6 to whether Sukan and Ugan had reunited after death of Jagannath.
No, we are not concerned with that. That is irrelevant. Your appeal is confined to the gift deed. That is what you have said.
Just for page 62, maybe see page 62.
Yes.
Last portion. The claim of the plaintiff respondent was not found sustainable on the basis of reunion, and accordingly, in this claim of plaintiff stands set aside. The rest of the relief granted by the Landlord to the erroneous and accordingly stands set aside. Accordingly, the judgment of Landlord stands modified to that extent, and accordingly, appeal is partly allowed. In fact, the Lord said the issue number 6, which was framed by the Landlord court below, that whether after death of Jagannath, the Sukan and Ugan, they have reunited and they lived in. But the witness of the Ugan, plaintiff himself, demolishes his case. He says कि हमको याद नहीं है कौन प्लॉट नंबर था कौन नहीं।
Reunion का क्या मतलब?
Reunion का है कि इन लोग का जो फादर का डेथ हुआ, there was a partition by meets and
एक बार पार्टीशन होने के बाद reunion का कॉन्सेप्ट है।
तो यही चीज तो है, तुम लोग तो ना डिफेंस द फ्रेम किए, and that has been found false by the London court.
The claim of plaintiff was not found sustainable on the basis of reunion. Certainly, reunion cannot take place once there is a partition.
So, what was the defense taken by the plaintiff? That Ugan and Sukan, they had reunited after death of the Jagannath, because Jagannath had died isole. So that has been found that it is not sustainable.
Certainly, it is
so
not sustainable.
after death of Jagannath, Urmila and her husband, they lived in his house as Ghar Damad and maintained his property.
घर दामाद होने से क्या succession हो जाएगा?
Succession तो नहीं
do not know.
होगी.
Whatever be the nature of succession, बेटी को तो हिंदू में वैसे ही succession है. घर दामाद की क्या जरूरत है?
तो adopt किया.
Not required.
तो उसका जो लड़का है राजेश यादव, जो उर्मिला का भाई है, सो सपोर्ट किया है केस को.
कि सपोर्ट करने से क्या होगा? सपोर्ट करेंगे कि पड़ोसी को गिफ्ट दे दिया और पड़ोसी सक्सीड कर गया।
इसका एडमिटेड फैक्ट है कि जो प्लेंटिफ एंड डिफेंडेंट नंबर 1, they are from the common ancestors and they are nephew and niece in relation.
You see, the claim of reunion was rejected, not sustainable. So they wanted some kind of succession. Therefore, the court has said that the property will devolve as per succession. Simple.
That was not the prayer made in the
Need not be, but they were claiming reunion, no?
Lord say, if the prayer has not been made in the play,
they were claiming reunion. But they claiming reunion.
Prayer I have read, Lord say, what was the prayer?
तो खाली prayer से थोड़ी होता है. What was the plaint about? They were claiming reunion.
No, they are taking the property of the Jagannath Mahato is in perfect possession of the plaintiff, and he is in continuous right title interest of the said has been perfected in favor of the plaintiff. That was his prayer. He has not said it will devolve upon the legal heirs of the Jagannath, class 2 legal heirs of the Jagannath Mahato. In fact, the plaintiff has claimed the entire property of the Jagannath Mahato. So there are two substantial questions, and first, onus has been shifted upon the defendant to prove. Plaintiff can't take weaknesses of the defendant. He has to prove his own case by his own pleadings and depositions. All revenue records are in favor of the Jagannath.
See, what is, you have only challenged the finding with regard to the deed of gift. That is only.
In fact, what say the entire judgment has under challenge.
आप तो देखिए ना, आप prayer ही क्या किए हैं? आप जरा देखिए पैरा 15 में. What is your prayer? You just read page number 15, last line.
ये कर रहे हैं. ये the learned district is hereby given finding held that the deed of gift is not enforceable, and he partially allowed the title appeal and set aside the judgment dated past was so only having the findings of the learned appellate court wherein he held that deed of gift is not enforceable.
Yes, this is what your relief is.
Deed of my
You are only concerned with the deed of gift.
my right accrues from the deed of gift, Lordship,
That's right.
and deed of gift and all the revenue records that shows that the
Revenue record से आपका title थोड़ी बन
नहीं
जाएगा.
टाइटल नहीं बनेगा. जगन्नाथ महतो का टाइटल बनता है ना, उसका तो
जगन्नाथ महतो का तो title is not disputed.
जो उसका तो डिस्प्यूट है भी नहीं.
फिर क्या? How will Urmila
Deed
Devi
of
get
gift
it?
that substantial क्वेश्चन बना के इसको डिटेल्ड हियरिंग कर
कैसे
दिया जाए।
क्या हियरिंग हम करें?
दो ही पॉइंट तो है बोल रहे हैं कि whether the deed of gift
The date of death. But the finding is, the evidence is that the date of death is prior to the deed of gift. Urmila Devi herself has stated that he died
उर्मिला
on.
देवी तो वो तो हम this question was put to her, she said कि वहाँ घबरा के मुंह से निकल गया।
कहाँ घबरा? कब पूछा गया उनसे?
तो हम जो पूछे, मैं जो उससे पूछा था।
आपने उनसे पूछा था तो आपका गवाही थोड़ी हुआ है?
नहीं, हमारा नहीं हुआ है। लेकिन लॉर्डशिप में सी
ऐसे घबरा के ऐसे
नहीं हम
we
जो
will not go beyond what is there in the record. She herself has stated Jagannath died on 8/4/99. Even from the statement of this witness, who is the main contestant, the date of death of his
डिफेंडेंट
becomes disputed.
है, उन लोग है सो 5/8 बोले हैं भादो महीना में हुआ है। इसका देखा जाएगा।
उससे क्या होगा?
मृत्यु प्रमाण पत्र निकला था जो उसको देखा जा रहा है, इन लोग नहीं एग्जीक्यूट किए थे वहाँ पर। इसमें
इसका हम लोग क्या करें? उसका हम लोग क्या करें अपने पास?
लेकिन डिफेंडेंट नंबर का जो दो विटनेसेस हैं, ये है सो बोले हैं लॉर्डशिप कि ये भादो महीना में मरा है।
तो इससे क्या होगा? डिफेंडेंट का विटनेस if it is contradictory, then what is to be done?
That was the observation, it is contradictory. That I am
It is
accepting it.
contradictory.
जो रिपोर्ट है, देखिए ना पेज 53 में है। पेज 53 स्टेटमेंट है, पेज 53 TW1 का है, he died in the year 99 in the month of Bhado. Second line. Then TW2 said in the year 19 the month of Bhado. TW3 has said in the month of Bhado. Second line. So Bhado. So Bhado generally August is there in our Hindu calendar, and dependent number 6 due to an anxiety and other things he could not say so, but the record says he died in August in 99. There is some fishy with regard to the date of death, because the plaintiff himself has said कि ट्रेन में आ रहे थे, झगड़ा हुआ तो खुला गया।
देखिए
Just one more, Lordship, page 50 may be seen. Page 50 of the impugned order.
just कोई finding है? What is the date of death? Is there any finding in the court regarding what was the date?
But DW6 has had said that.
That's right. Is there any finding? Date death कब हुआ है? नहीं है ना? ऐसा तो फाइंडिंग नहीं दिया है, खाली लिखा है कॉन्ट्रडिक्टरी एविडेंस।
बट लेडीज DW6 ने खुद कहा कि जगन्नाथ
हाँ ठीक है, कहा है, लेकिन फाइंडिंग कोर्ट ने नहीं रिकॉर्ड किया है डेट ऑफ डेथ, राइट? विद रिगार्ड टू अ रजिस्टर्ड डीड देयर इज अ प्रिजम्पशन ऑफ करेक्टनेस, देयर इज अ प्रिजम्पशन दैट इट हैज बीन ड्यूली एग्जीक्यूटेड, इजंट इट? उस प्रिजम्पशन का क्या होगा? 10/6 को जगन्नाथ महतो had gone to execute a gift deed in favor of Urmila Devi. So it cannot be assumed that a dead person had gone there. So there is a presumption in connection with registration of a document. So that presumption has been completely not taken care of by the court. There was conflicting evidence. There is no finding that no finding has been recorded with regard to date of death. Second appeal number 542 of 2018. कहाँ से फाइंडिंग है?
तो यही उर्मिला
अरे भाई वही बोल रही है तो क्या हुआ? आप समझ नहीं रहे? समझ है ना? रजिस्टर्ड डॉक्यूमेंट है, उसका प्रिजम्पशन देखेंगे कि नहीं देखेगा कोर्ट?
हाँ देखे।
कहाँ देखा है?
But she has demolished her own case.
Maybe there is conflicting evidence. There is no finding. There is no finding recorded by both the court regarding the date of death of Jagannath. Has the court recorded any finding? The court has simply said that there is conflicting evidence. What will happen to the presumption under the Registration Act so far as a registered document is concerned?
But
that has not been taken care of. सुनेंगे आपको?
हाँ वो तो ठीक है।
सुनेंगे। अभी substantial question of law है।
इसीलिए हमने इस पर।
अभी आपका कोई काम नहीं। बहस नहीं करते हैं सर, रीट पिटीशन नहीं है ये। Court will argue for you. Second appeal number 542 of 2018. The learned counsel for the appellant has submitted that the registered gift deed dated 10/6/1999 has been sought to be disbelieved by both the courts. On the ground that there was conflicting evidence with regard to date of death of Jagannath Mahto. He has submitted that the gift deed was in favor of Urmila Devi, who belonged to the common ancestor as that of Jagannath Mahto. And though she said that Jagannath Mahto had expired on 8/4/99, which was a date which was neither claimed by the plaintiff nor claimed by the defendant. The plaintiff claimed that he died on 4/5/99. Urmila Devi deposed that he died on 8/4/99. Other defendants deposed that he died in the month of Bhado of the year 1999, which corresponds to the month of August 1999. The learned counsel submits that there is no finding recorded by both the court with regard to the date of death of Jagannath Mahto. However, the gift deed has been disbelieved. He has submitted that the courts have not considered the presumption in connection with execution of a registered document, and therefore a substantial question of law being framed in this case. After hearing the counsel for the appellant and considering the facts and circumstances of this case, this second appeal is admitted on following substantial question of law. Whether the learned first appellate court could have held that the gift deed was not enforceable that the registered gift deed executed by Jagannath Mahto in favor of Urmila Devi was not enforceable. इशू नोटिस आप हैं कोई और भी है साथ में
सही
इशू नोटिस टू द सारे रिस्पोंडेंट्स की तरफ से टू द रिस्पोंडेंट्स द मिस्टर सो एंड सो नाम बताइए अपना मिस्टर नाम waives notice on behalf of the respondents as he has already entered clearance that the records be called for from the concerned court post this case under the heading for final disposal on कब करेंगे बताइए बताइए कब करेंगे choose your date 20 seconds second
Item 15, second appeal 22 of 2020.
what is it
It relates to possession and perpetual injunction. My senior has to assist with
when you want
immediately next week.
at the request of the counsel for the applicant post this case on next month.
Item 16, second appeal 16 of 2022.
This is defendant's second appeal against judgment of affirmance.
Judgment of
Concurrence affirmance.
what is the relief?
Relief was sought by the plaintiff. Plaintiff is the respondent
Is
here.
there any question of law involved?
Yes.
It is a question of law. Let's have it.
Only two line I will say, my lord. Their plaintiff's specific case is that defendant on the basis of a registered document of the year 1928, registered document of the year 1928, the defendants are claiming, means we are claiming. This is the case of the plaintiff. And the defendant's case is that in the year 1930, that they are the recorded tenants and they are continuing in possession, and both the courts have discarded two documentary evidence. First, registered document evidence, which was in my favor, and only on the ground that there was no recital regarding that this land was abandoned by the rajah. Apart from this matter, there is second substantial question of law. Trial court has not given any relief relating to recovery of the possession. Trial court has declared title. A specific relief was claimed by the plaintiff that a decree for recovery of possession, because this is the defendant's case, plaintiff's case, that we are in possession. They sought a specific separate relief. This relief was not granted. They not challenge the judgment of the decree. In my appeal, they file an application that this decree should be granted to me. The learned first appellate court correctly said that Order 41, Rule 33, read with Section 107, gives power to grant relief. Now that relief has to be granted in the appeal filed by the plaintiff, not in my appeal. He has not challenged the appeal. So, my lord, straightforward, just my lord, kindly have a look to para 21 of the first appellate court's judgment.
You come to the question of law which you want to point out.
My lord, question number 5 and 6. And 9.
What is Exhibit 6?
Exhibit 6 is the registered deed of 1930 by virtue of which 8 anna share of the then landlord was transferred to some other persons, not the plaintiff. They are saying that they were paying rent to the subsequent transferee after 1930. My registered deed, which we were claiming on the basis of 1928 registered deed. That is on record. Exhibit A. And thereafter, my lord, there is a provision for rent reduction, because if sometime rent is excess, the rajah has a right under CNT Act to reduce the rent. I filed an application in the year 1940, and a certificate is granted in that procedure. I filed that certificate. Exhibit C is there, but both the court has discarded on the ground. Exhibit A is discarded on the ground that there is no recital of abandonment, and Exhibit C is granted कि नहीं आप पूरा entire order sheet क्यों नहीं लगाए, केवल आप certificate क्यों लगाए. And third is, my lord will see paragraph 21 of the first appellate court. Specific there is finding of the first appellate court कि नहीं वो नहीं प्रेयर किए, लेकिन हम इनके अपील में भी हम ग्रांट करते हैं.
Substantial question of law 5, 6
and 9.
9. Is it sufficient?
Yes.
Okay. Second appeal number 16 of 2022. counsel for the appellant has submitted that this is defendant's second appeal. Against the judgment of affirmance. However, he submits that substantial question of law are involved in this case. He has in particular referred to substantial question of law number Roman 5, Roman 6 and Roman 9, and has submitted that the documents have been wrongly construed by the learned courts while passing the impugned judgment. Considering the submissions and having gone through the impugned judgments, the substantial question of law is admitted for hearing. This appeal is admitted for hearing on the following substantial questions of law: Roman 5, Roman 6 and Roman 9. Issue notice to the respondents for which requisites under ordinary process be filed within a period of 1 week. Let the records be called for from the concerned courts. Pose this case under the heading for final disposal on October 6th.
Item 17, second appeal 238 of 2023.
This is arising out of a landlord-tenant dispute. I was the tenant, whereas I was defendant in the suit. Yes, thereafter we filed an appeal which was dismissed. Lordship will recall, the Lordship kindly take the order dated 3/7/2020. This is the case in which the defense was struck off.
These two A and B.
Yes, sir.
For the learned counsel for the appellant. The learned counsel for the appellant has submitted that in spite of the defense having been struck off, the evidence and of the defendant, evidence and
written statement.
And written statement of the defendant has been taken into consideration. By passing the impugned judgments. He has referred to the supplementary affidavit dated 11/7/2025 and has submitted that two substantial questions of law have been suggested in paragraph 4 of the supplementary affidavit which arise for consideration. After having heard the counsel for the appellant and having gone through the impugned judgments, this appeal is admitted on the aforesaid two substantial questions of law. Issue notice to the respondents for which requisites under ordinary process be filed by the appellant within a period of 1 week from today. Place this case for, since the matter arises out of landlord-tenant relationship, correct? Place this case for final disposal on October 6th, 2022. Let the records be called for from the concerned court. Let this order be communicated through fax. तो previous का भी fax में communication का. Deposit special messenger post. Special messenger post. Let the records be called for from the concerned court upon deposit of special messenger cost by the appellant. It will be done within a period of 1 week.
For hearing, item 18, second appeal 241 of 2018.
Ms. Appellant.
dated 9/20, and substantial question was that whether the learned court below approached the suit from wrong angle which resulted in failure of justice. Secondly, whether the learned court below erred in law that the judgment of the lower court is based on lies and mutual.
कहाँ से पढ़े थे?
Your Lordship, may see the order by which this was applied.
31/23.
Yes. It is 30th of January 2023. Four questions of law.
Where is the other side? They have appeared, not appeared. Somebody is appearing for the respondent, Mr. Mithilesh.
Yes, state is there.
State.
State, therefore.
Private respondent have not entered.
No, private respondents are not. Only state is there.
Where is the counsel for the state?
This thing.
Counsel for the appellant is present. The private respondents have not entered the case in spite of service of notice.
Private respondent is not there.
Yes, that's right. What about state? State is
State,
also
yes, state is not.
nobody is appearing on behalf
Yes.
of the state. In order to give one more chance to the counsel for the appearing respondent, when this matter will be for final disposal on Monday,
Whatever is.
next to next Monday,
That's your Lordship.
next to next Monday.
Whatever is correct.
Let a copy of this order be forwarded to the office of learned advocate general to ensure appearance of the counsel of the state.
Item 19, second appeal 425 of 2018.
It has been admitted by terms of order dated 20/12/2023. Two substantial questions of law have been framed.
Respondent has appeared.
They have appeared one or two.
Who is appearing? Counsel for the appellant is present. Nobody appears on behalf of the respondent. In order to give one more chance to the respondent, pose this case for final disposal on next Monday.
Next Monday, after 15 days, just I have been informed my auntie passed away. So I will go to my village.
On कौन सा डेट होगा उसके बाद?
15 दिन के बाद
11 तारीख 11th August.
Yes.
On 11th August, under the heading of final disposal, office is directed to forward a soft copy of this order to the counsel for the respondent to ensure his appearance.
Deeply.
Item 20, second appeal 539 of 2018.
this appeal against the reversal by the appellate court. The main suit was filed by the plaintiff, my lords, for declaration of right title and interest over the Schedule A of the suit property.
Where is the substantial question of law framed?
Substantial question of law framed, my lords, two substantial question of law has been framed. Firstly, whether the first appellate court, while reversing the judgment of the trial court, while not considering the issue number 2, and also the prayer of the plaintiff in respect of partition of the property in question has committed illegality. Second is
By which order it has been framed?
by order dated 16/12/2021.
16/12.
2020.
Sixteen 12/21. Who is for the respondents? It was a suit for partition.
It was of two different lists. Firstly, for declaration of right title and interest over the Schedule A of the suit property, and second was for the partition of the Schedule B of the suit property.
So the partition part has not been taken care of by the first appellate.
Also, my lords, even if it is assumed that the plaintiff has right title and interest over the Schedule A of the property, that itself would not entitle him for the entire share of Schedule A of the property.
Why?
Lords, because entitlement of right title and interest over the suit property doesn't allocate the share what he will be getting in the suit property.
Entire ko nahi milega.
Entire nahi milega.
See, if he says that it is his own property.
No, he is not claiming. He is claiming that by way of a registered adoption deed.
Adoption.
Which itself is challengeable because the taking and giving ceremony has not been proved by any of the witnesses, except this plaintiff. Neither the execution of the deed has been proved by any of the testing witnesses.
Execution of the deed, it is a registered document.
Registered.
So, it is a deed by.
The appellate court also has drawn.
You see, so far as the finding on the point of adoption is concerned, that is not the subject matter of the substantial question of law. So we will not touch the finding of adoption. So adoption has been disbelieved by both the courts.
Appellate court has presumed that the adoption is valid since it is
not
registered
presumption.
document.
That is not the substantial question of law. So we will, whatever be the presumption or assumption or whatever be the finding, we will not go beyond whatever has been, whatever is the substantial question of law. So your contention is relief number 3 has not been granted. What is the point of determination framed by the learned first appellate court? The first appellate court did not frame any relief in connection with Schedule B property.
It subsumed the entire relief of the plaintiff in the second issue it has done.
Whether the appellant plaintiff has got right title interest over the suit property. Adoption has been held to be valid.
On the basis of presumption of section
Whatever, we do not know about it. Whatever it is, that is not the subject matter now. Now, where is the finding with regard to issue number 2?
Issue number 2, my lords.
allocated.
After going to the facts and circumstances of the case, it transpires that the plaintiff, Sampudan Loha, has brought the incident suit against the defendant and the award is asking for declaration of right title and interest and confirmation of petition over Schedule 8 land or for recovery of possession of first partition of suit property on the basis of Exhibit 4, which is registered with the whereas the contesting appellant has vehemently applied the claim of the appellant on the plea that adoption of the appellant has been procured by fraud. In the backdrop of the pleadings of the parties and findings arrived with the learned note for deciding issue number 5 and 6 has came to the conclusion in favor of the defendant merely on the basis of order dated 49/1982 passed by sub-divisional officer of Jamtara immigration case number 138/1979, which is exhibit 2 in this case, as it mentioned that in the appropriate order that at the time of adoption Sampala was 20 years old, 22 years old and he was married also, and pleased to dismiss the suit for non-fulfillment of provision of section 10 of the Adoption Act. Maintenance. But I do not find any documentary evidence in support of the fact that Sampala was 22 years old at the time of adoption. The provision of section 16 of the Adoption and Maintenance Act states as under whenever any document registered under any law for the time being in court is produced before the any court purporting to record an adoption made and is signed by the person giving it and the person taking the child in adoption, the court shall presume that the adoption has been made in compliance with the provision of this act unless and until it is disproved. On their reading of the provision of section 16 of the Adoption and Maintenance Act, it clearly says that there is a presumption of genuineness attached to adoption. However, such presumption can be rebutted by proper evidences. In this case, Exhibit 4 registered deed of adoption number 85 of 1975 has been filed by the appellant and the respondent. Defendant wants to displace the presumption attached to this registered deed. Thus, in my opinion, burden of replacing the presumption under section 16 of the Adoption and Maintenance Act lies to the respondent defendant, but the respondent defendant has miserably failed to do so. The plaintiff has asserted in his plea that due to death of Kinkar Lohar's wife in the year 1973, Kinkar Lohar adopted Shampata Lohar, appellant of the incident suit on 18/3/1975 as his adopted son, and subsequently executed a registered deed of adoption dating number 85 of 1975 in sub-registry office, County Jamtara. And after adoption, plaintiff Shampata Lohar started living in the house of Kinkar Lohar as his adopted son, and after death of Kinkar Lohar in the year 1979, the plaintiff and the defendant amicably partitioned the entire property left by Kinkar Lohar, and Schedule 8 property was exclusively allotted to the plaintiff. And plaintiff has constructed his residential house on a portion of plot number 2509 and has been residing there with his family and got mutated a scheduled land in his name, wide mutation case number 135 of 1979, which is exhibit 2 in this case. The respondent filed title suit number 60 of 1985 for cancellation of adoption of the appellant, and the appellant contested the aforesaid suit, filing WS, but aforesaid suit was dismissed by order dated 23/5/1996, which is exhibit 3 in this case. The respondent has neither taken any step for restoration of the aforesaid suit nor has he filed any appeal against the dismissal order dated.
Yes, issue number 2 has counsel responded.
Yes, sir.
The learned first appellate court framed 2 points for consideration. Whether the adoption is valid, and other is whether the plaintiff has got right title interest over the suit property. Suit property was A and B both. Right? So, there is no finding in connection with the suit property.
Your Lordship, the suit property B includes suit property A.
Okay, fine. But there is no finding in connection with Roman 2. Roman 2, where is the finding in connection with point of determination number Roman 2? Has he recorded any finding? पूरा तो जजमेंट ही इसी पर है adoption पर, and last paragraph में खाली ये किया है that adoption is valid. If the adoption is valid, then the Roman 2 need not be answered. Tell us. There is no finding. Schedule A property is a part of Schedule B property.
Yes, sir. Schedule B includes Schedule A property.
Okay. So he was. Who were the parties before the court?
Shyamapada Lohar, my lord.
Yes.
And my lord, this
What is the genealogy?
Shyamapada Lohar has said, my lord, that he was the adopted son of, my lord, that Kinkar Lohar.
Kinkar Lohar, right? And there was a partition suit between Syamapada Lohar and who claimed to be the adopted son and the daughter of Kinkar Lohar. दोनों भाई बहन के बीच में झगड़ा
हाँ,
करेक्ट
मतलब इस ये जो पार्टीशन सूट का जो टाइटल है हम लोग इसको अगर ठीक से देखा जाए इट्स merely a title but the entire suit which relates to blood is not the right title in interest. Since Lord he has said that after the death of Kinkar Lohar they have amicably partitioned 50% of their property, मतलब 50-50 and Lord जो इसका जो श्यामापदा लोहार का जो 50% आया था उस पे वो अपना म्यूटेशन वगैरह सब करा चुके थे. Subsequently in the year 2009 or about something, this Lord the Thandawala Dasi Lord the Lohar in the sister Lord, she has Lord came and mutated the land Lord the entire land. Thereafter Lord he is saying that he has a cause of action since Lord 50% property जो था, so Lord he said that property was already divided. So only thing which he has prayed Lord that was the right title and interest of that property. And the property of schedule A, B or A property. Said schedule A property. He has said in the plain Lord कि जो schedule A property जो है जो कि which schedule B property includes तो उसका उनका कहना था either schedule A में हमको डिग्री दे दिया जाए 50 पे या फिर Lord अगर अलग से डिग्री होता तो उसे कार्व आउट करके कर लिया जाए. That is entirely
जिस तरह से बहस कर रहे हैं ना उस तरह का हम जजमेंट नहीं लिख पाएंगे.
yes, I'm sorry Lord.
He was claiming partition of schedule B property also.
Yes, B property.
Where is the finding? Is there any finding with regard to schedule B property?
No.
There is no finding. तो ये कहाँ है? कोई भी finding नहीं है.
That's one more thing I would like to correct. That schedule A property was claimed by the plaintiff himself. The plaintiff is the adopted son who has filed the suit for right title and declaration of right title and interest. And he has claimed that both the sole surviving daughter as well as the plaintiff has amicably partitioned the suit, and schedule A has been specifically taken by the plaintiff himself, which is the case of the plaintiff also. And according to him also, the surviving daughter of the appellant hearing has right title over the schedule B property. And when the schedule
A is not a part of schedule B property.
In the description of the property, schedule of the property, both the properties have been differently mentioned.
So schedule B property was of that of the daughter.
It is the averment of the plaintiff. It is not the case.
That's right. It is the averment of the plaintiff. The schedule B property belongs to the defendant.
But when the defendant mutated the claim in 2008-9, it is the averment of the plaintiff. I can show from the plaintiff.
You read it from here, from the trial court judgment.
The averment of the plaintiff, my lords. I am reading the judgment.
You read it from trial court judgment.
Madam. Plaintiff Syamapada Lohar has filed this suit against defendant for declaration of right title and interest and confirmation of possession or for recovery of possession or for fresh partition of the suit property. The brief fact of this suit, as according to the plaintiff filed on 18/5/2010 by plaintiff Syamapada Lohar against defendant, is that the properties mentioned in schedule of the plaintiff were recorded in the name of Rakul Lohar and Sabu Lohar in the last survey settlement. Rakul Lohar, recorded tenant and wife of Sagar Lohar, died issueless. So after her death, the property is standing in her name and share devolved upon Sabu Lohar, who was younger son of Sagar Lohar, husband of recorded tenant Rakul Lohar. And in this way, Sabu Lohar became the exclusive owner of the entire land of Jodh number 102 of Moja, Garjuri. Sabu Lohar died leaving behind his son Kinkar Lohar, and after the death of Sabu Lohar, Kinkar Lohar became the owner of all the lands of Jodh number 102 of Moja, Garjuri. Kinkar Lohar had only one daughter, namely Thandawala Lohar, which is defendant of this case. In the year 1972, wife of Kinkar Lohar died so on 18/3/1975. Kinkar Lohar adopted Syamapada Lohar, the plaintiff of this case, as his son, and Kinkar Lohar, along with his natural mother of the plaintiff, with the death of natural father of the plaintiff at the time of adoption, executed a registered adoption deed bearing number 85 of 1975. After the act of adoption, the plaintiff started living with his adopted father. After the death of Kinkar Lohar in the year 1979, both the plaintiff, namely Shyampada Lohar, and the defendant, namely Thandapala Lohar, jointly inherited their half of share. After the death of Kinkar Lohar, there was amicable partition between the plaintiff and the defendant, and the properties mentioned in Schedule A of the plaintiff came in possession of the plaintiff, in which the plaintiff constructed a residential house and started living with his family. The plaintiff started paying rent also because the land was mutated in the name of plaintiff by mutation case number 138 of 1979. In the month of June 2019, the plaintiff got information that the entire land of Jot number 102 of Modagadori, shown in Schedule B of the plan, has been mutated in the name of defendant. Against the order of the mutation, the plaintiff filed a revision in Court of Law, Deputy Commissioner Jamtara, bearing miscellaneous revision number 9 of 2019, which is still pending. The defendant has filed a title suit bearing number 16 of 1985 in the Court of Law, subordinate Judge Jamtara, challenging the adoption deed number 85 of 1975, which was dismissed on 23/5/1996. The plaintiff is still in possession of the properties mentioned in Schedule A of the plaintiff, having his house on plot number 2509, and the defendant has no title. As the defendant is trying to dispose the plaintiff out of the land of which the plaintiff is the sole claimant in the capacity of the adopted son of Kinkar Lohar, the plaintiff has to file the suit for declaration of right title interest and possession of the land mentioned in Schedule A of the plan, or alternatively for recovery of possession and for partition of the land mentioned in Schedule B of the plan, and ultimately for delivery of possession. The defendant has filed the written statement. In the written statement of the defendant in nutshell, the defendant has stated that the parties to the suit are Hindu government, Daksha school and genealogy given by the plaintiff in Karachi of the plaintiff is not genuine, rather the plaintiff has strongly inserted his name as adopted son of Kinkar Lohar with implied intention. It is a fact that Kinkar Lohar had no son, but it is also a fact that Kinkar Lohar has a daughter named Thandapala Dasi. So he never adopted Shyampada Lohar as his son. Quite contrary to the pleading of the plaintiff is living in the house of Guru Lohar, and he is possessing his paternal property. The defendant also says that the mother of the defendant died in 1968, not in 1973, and the entire claim of the plaintiff is imaginary and baseless. Again, it has been
But once the adoption was held to be valid, the partition has to be there. Either they would say that there was a previous partition and therefore Schedule A property belonged to the plaintiff, or they would say that there was no previous partition because the defendant was claiming right over the entire property of Schedule B. So, but there is no finding as to whether on the point of issue number 2. There is no finding.
हाँ एक चीज हम लोग इसमें बता रहे हैं नोट से पहला बात जो learned appellate court has said that there was a valid adoption
Yes.
that there was a valid adoption and the plaintiff the father of the the original defendant and the plaintiff has adopted this defendant and
There is a valid adoption. Yes. This is in favor of the appellant.
Yes. This is in the favor of appellant.
Yes.
Therefore, earlier the contention was rejected by the trial court.
We are not bothered about it. That is not the substantial question of law.
Yes. Earlier, no, I am saying that the earlier that contention was rejected in appeal that was held that the adoption deed was valid. So, the right title question was denied by the trial court only because that the adoption deed was not a valid.
That's right. Then the sole daughter would have inherited.
Yes, subsequently, according to the plaintiff, which he has said that after the death of the Kinkar Lohar 50% property.
आप कहाँ जा रहे हैं भाई? Substantial question of law में focus करिए ना. पूरा कहानी क्या सुनना है? There are 2 points of determination framed. Yes. Where is a finding in connection with the second point of determination?
The first point of determination was interlinked with the second point of determination. For example, if it is found that the adoption deed was valid, then partition has to be taken place, yes, or the right title of interest
has the partition been decided? No.
The right title, the 50% of
only 50%, but has that been decided?
इसमें last paragraph में दिखा जाएगा. Last paragraph.
Appellate court judgment.
There was a determination.
Where is the determination of 50%?
इसमें ये हमको एक्चुअली कॉपी ऑफ ये नहीं दिया है, therefore
बहुत अच्छी बात है,
having
बहुत अच्छी बात नहीं दी है।
problem
He has simply stated that as such I find and hold that the appellant plaintiff has got right title and interest over the suit property.
yes Lord.
कैसे ये finding record कर देंगे? Partition का होगा ना finding, because it is not the case of the plaintiff that he will be entitled to the entire suit property.
Plaintiff has not said that he is the entitled.
Yes, that is not his case, but this is what the appellate court has done.
Lord, एक बार खाली हमको एक बार प्लेंट का उस हिस्सा को पढ़ने दिया जाए जिसमें वो बोला है कि जो 50% है उस पर राइट टाइटल इंटरेस्ट डिसाइड हुआ है, नाइदर मतलब शेयर हैज बीन डिसाइडेड, शेयर वाज नेवर बीन द क्वेश्चन। वो कहा कि हमको 50% शेयर उसी समय मिल गया एंड आई हैव म्यूटेटेड दैट वन।
The 50% share which he got was in relation to Schedule A property. He claimed that he has received 50% share with respect to Schedule A property, in which the mutation was already done.
Yes.
And Schedule B was the entire property.
Yes, Lord. Which includes Schedule A property.
Which includes Schedule A property.
Yes,
right?
Yes.
Now he said that he has already got Schedule A property, but the defendant claimed that the entire property belongs to the defendant. Right? Therefore, under such circumstances, either the court would have held that there was a previous partition, there is no such finding, or the court would have held that yes, the property is required to be partitioned. The court has neither held that there was previous partition and therefore the plaintiff would be entitled to the suit property with regard to Schedule A. बताइए, यहाँ पे लिख दिया है as such I find and hold that the appellant has got right title and interest over the suit property. इसका मतलब पूरा Schedule B, Schedule A, everything. That is not his case.
If your lordship says so, in such circumstances, I may be permitted to submit, if your lordship's held, that कि इसको जो है ये this was not done accordingly, कि Schedule A और Schedule B का there must be some recording, some finding. So हमारा इसमें एक contention है within the meaning of order, हम बता दे रहे CPC देख के हुए, according to that there is sufficient materials before your lordships, so since the suit is coming since long, everything is on record, everything has been the only thing was to come at a finding, so if your lordships come, there is a क्योंकि वो जो order है, I don't have CPC, हम भूल गए जल्दी हड़बड़ी में केस पकड़ाते तो जो उसके मुताबिक हुजूर के पास ये पावर है हुजूर कि जो रिकॉर्ड में है उसको देखते हुए हुजूर अपना खुद का फाइंडिंग दे सकते हैं।
सब्सटेंशियल क्वेश्चन ऑफ लॉ के बियॉन्ड तो नहीं डिसाइड करेंगे
नहीं, उसमें है, उसी में है, हम सीपीसी में दिखा दे रहे हैं हुजूर, हम सीपीसी में दिखा दे रहे हैं कि अगर वो है तो सीपीसी मींस इंस्टेड ऑफ रिमांडिंग और एनीथिंग माय लॉर्ड में इटसेल्फ गिव अ फाइंडिंग टू दैट इफेक्ट इफ द रिकॉर्ड्स सिंस
partition is a factual aspect that has to be ascertained by
there is
important evidences.
It has to be done by meets and bounds, ना? कैसे हम यहाँ से partition ऐसे decide करेंगे?
It has to be demanded for partition.
बताइए, the partition has to be done by meets and bounds.
ये लॉर्डशिप इसमें हम एक छोटा सा खाली बोलेंगे, इसको कल फर्स्ट केस में रख दिया जब बिकॉज़ इसको इसमें जो कल फर्स्ट केस में
नहीं करेंगे, एकदम नहीं करेंगे. The appellate court has not recorded any finding with respect to point number 2. Suit property is Schedule A and Schedule B.
हमको एक चीज अभी कहने दिया जाए, इसमें क्यों हम why I am praying इसमें substantial
your prayer is rejected.
ये yes लॉर्डशिप ठीक है लेकिन हम क्यों बोल रहे थे खाली हमको
हम
इसमें जो substantial question of law है मुझे इसमें issue number 2 लिखा हुआ है. That is issue number 2. That is not a point of determination. I have prepared myself with regard to issue number 2 इसमें देखा जाए हम तो वो जो substantial question of law है हम उससे करके आएंगे हुजूर preparation myself. अगर अचानक से
issue number 2 वही appellate court का ही judgment का है.
issue number 2 नहीं, that is a
appellate court के ही judgment का issue number 2 है.
That is point of determination.
ठीक है, आपकी बात समझ.
appellate court में भी issue number 2 लिखा, हम दिखा देते जजमेंट से दिखा देते, हम issue number 2 दिखा दे रहे हैं जजमेंट से, हम उसी को देख के आए हैं.
आप सीधी बताइए point of determination number 2 पे कोई finding है कि नहीं है? Is there any finding by the first appellate court on that?
But point
अरे भाई आप आंसर क्वेश्चन का आंसर करेंगे कि हमें अपना जजमेंट लिखाना शुरू करें हम? I am just asking you a very simple question. Is there any finding of the learned first appellate court on the point of determination number 2?
Point of determination number 2 में specific finding वैसा नहीं होगा.
Specific क्या कोई भी finding नहीं.
Specific finding ठीक है वजूद नहीं.
There is no finding.
इसमें एक बार order 23 हम एक्चुअली में हुजूर हम इशू नंबर 2 देख करके आए डिटरमिनेशन.
आप जो देख के आए आपकी गलती है ना, इसमें हम लोग क्या कर सकते हैं? आपकी गलती को तो हम लोग सुधार नहीं कर
क्वेश्चन ऑफ लॉ में वही लिखा
सकते. ठीक है कोई बात.
ऑर्डर 23 रूल
वैलिड कॉज ऑफ एक्शन पे तो कोई डाउट ही नहीं. इसमें तो इशू नंबर 2 बस वैलिड कॉज ऑफ एक्शन, इसका क्या रेलेवेंस है? So first step.
Yes, ma'am. Order 23, order 41, rule 24. Where evidence on record sufficient, appellate court may determine case finally. Where the evidence upon the record is sufficient to enable the appellate court to pronounce judgment, the appellate court may, after resettling the issue if necessary, finally determine the suit, notwithstanding that the judgment of the court from whose degree the appeal is preferred has proceeded wholly upon some ground other than that of which the appellate court proceeds. Order 23 rule, order 41 rule 24 rule. So, and where the appellate court may frame issue and
Order 41 deals with appeal from appellate degree. It is not dealing with second appeal.
So, second appeal is also an appellate jurisdiction, Lord. Because इसमें देखा जाए ये और it doesn't distinguish between the appeal first appeal for the district court or the high court. Power is the same and similar, Lord. So if
Section 100 of CPC has to be read out, which says that the scope of second appeal is very limited. It has to be.
अरे भाई इनके कहने से थोड़ी जजमेंट लिख देंगे. लिखिए ऐसे नंबर 539 of 2018. For the learned counsels appearing on behalf of the appellant, on behalf of the parties. This second appeal was admitted for final hearing on following substantial question of law by the order dated 16/12/2021. Quote कर दीजिए. The learned counsel for the appellant. The records of the case reveal that the specific case of the plaintiff was that the plaintiff was the adopted son of Tinker Lohar, who had properties mentioned in Schedule B of the plate. It was his specific case that the sole dependent was the only daughter of Tinker Lohar. However, on account of adoption, he was entitled to 50% share of Schedule B property. It was his further case that so far as Schedule A property is concerned, which was half share of Schedule B property, stood mutated in the name of the plaintiff by virtue of previous partition between the plaintiff and the defendant. However, later on, the defendant was trying to dispossess the plaintiff by claiming to be the sole legal heir and successor of Kinkar Lohar. And therefore, the suit was filed for declaration of title with respect to Schedule A property of the plaintiff, and in the alternative for partition of Schedule B property, and a preliminary decree for half share of the plaintiff in the property, and then for a final decree with respect to half share in Schedule B property. The learned counsel for the appellant. The defendant had contested the suit by filing a written statement and questioned the validity of adoption of the plaintiff and claimed that the defendant had right, title and interest over the suit properties, being the legal heir and successor of Kinkar Lohar, whose last rites was also performed by her. The learned trial court framed the following issues for consideration. Both the parties led oral and documentary evidence. The learned trial court held that the adoption of the plaintiff was not valid and consequently dismissed the suit. So far as the learned first appellate court is concerned, 2 points for determination were framed. 1, whether the adoption deed is a valid document or not. Roman 2, whether the appellant/plaintiff has got right, title and interest over the suit property or not. The learned counsel for the appellant has submitted that the learned first appellate court has held that the adoption was valid.
The presumption of success.
No, whatever, adoption was valid,
That was not proved by another witness.
and further recorded that the mutation does not create any right, title and interest of the parties over the suit land. Although the suit land was mutated in favor of the defendant by the order dated 23/5/2007 in case number 77 of 2006-7, as well as the plaintiff by the exhibit 2, which is order dated 14/9/1982 in mutation case number 138 of 1979-80, and further held that it has already been established that adoption deed is a valid document and the defendant failed to disprove it, and the learned first appellate court held that the plaintiff has got right, title and interest over the suit property. The learned counsel for the appellant has submitted that the learned first appellate court did not consider the point of determination number 2 properly, inasmuch as the plaintiff was claiming only half share of Schedule B property, which constituted Schedule A property. He has also submitted that the court has not entered into the decision with respect to the share of the parties. He has also submitted that there has been no adjudication with respect to previous partition claimed by the plaintiff with respect to the suit property with defendant number 2, with the defendant. The learned counsel has submitted that on account of the aforesaid facts and circumstances, both the substantial questions of law are fit to be answered in favor of the appellant, and the matter may be remanded to the first appellate court for passing appropriate order in connection with the partition of the Schedule B property. As the adoption having been held valid, the plaintiff has a share in the Schedule B property. He has also submitted that the claim of previous partition is also required to be adjudicated. Counsel for the respondents has, on the other hand, has opposed the prayer and has submitted that the appellate court has recorded that the plaintiff has got right, title and interest over the suit property. He has further submitted that the materials are already available on record and the matter can be finally adjudicated by this court in the second appeal itself, and the issue which has not been decided by the learned first appellate court can also be decided. He has referred to Order 41 Rule 24 of CBC, which actually deals with the power of the court by dealing with first appeals. In response, the counsel for the appellant has submitted that the second appeal is to be decided on the substantial question of law framed by the court, and therefore, if the substantial question of law is ultimately decided in favor of the appellant, the matter has to be remanded to the first appellate court, as other issues are also, other connected issue in connection with partition is required to be decided and taken care of once the adoption is finally held to be valid by the first appellate. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the plaintiff claimed to be the adopted son of Kinkar Lohar, and the suit was filed against the daughter of Kinkar Lohar, who was the only daughter, against the only daughter of Kinkar Lohar. The plaintiff claimed 50% of Schedule B property on the basis of adoption by Kinkar Lohar. This court finds that the first appellate court has ultimately held that the adoption was valid, but so far as the right, title and interest with respect to suit property is concerned, which was relating to issue number 2, point of determination number 2, framed by the learned first appellate court. The learned court has simply held that, the learned first appellate court has simply held that appellant/plaintiff has got right, title and interest over the suit property, without considering the fact that, without qualifying as to whether the court was referring to Schedule A property or to Schedule B property. This court also finds that the learned first appellate court completely failed to consider the consequence of the finding regarding adoption and the further relief which was prayed for by the plaintiff claiming partition over the suit property or previous partition as claimed by the plaintiff. The learned first appellate court has not gone into the substantial question of law number 2 at all, and consequently neither the substantial question of law neither the point of determination number 2, which has been termed as issue number 2 while framing the substantial question of law, has been decided, nor the share of the respective parties has been decided. Consequently, both the substantial questions of law are answered in favor of the appellant and against the respondents. However, the matter does not end here. The needful is required to be done by the learned first appellate court with respect to claim of previous partition/partition. Accordingly, the matter is remanded to the first appellate court for remitted to the first appellate court for deciding the issue regarding partition with respect to the suit properties. The parties to appear on the particular date. एक date fix कर देंगे appear हो जाएगा. Since the suit कब का है ये?
पुराना है.
नहीं. Since the suit is of the year
2010 का.
suit. Since the partition suit is of the year 2010, since the suit is of the year 2010, the learned first appellate court shall expeditiously decide the appeal. It is made clear that the finding of validity of adoption is not interfered with by this court. Parties to cooperate. डेट आपको मिलेगा, आप सर्टिफाइड कॉपी अप्लाई कर दीजिए. जब भी ऑर्डर अपलोड होगा उसे कम से कम 2-2.5 महीना का टाइम जरूर दें, क्योंकि अगर अपील करना हो तो अपील कर लीजिएगा SLP, और वहाँ जाना हो तो वहाँ चले जाइए.
SLP नहीं करना.
किसी को मन कर सकता है ना,
कर सकता है,
इसीलिए उतना जगह उतना टाइम हम दे देते हैं.
इसमें कुछ डिफिकल्टी बिकॉज द एग्जीक्यूशन में दे आर फेसिंग,
तो उसी में तो कोई इसमें दिक्कत है. अरे भाई दोनों का 50% भी तो शेयर मीट्स एंड बाउंड से डिसाइड होगा ना. पता चले कोई प्रॉपर्टी बेच दिया कोई. देयर आर सो मेनी थिंग्स व्हिच मे कम अप.
वी कैन मोर क्लैरिफाई द इशू. सो something has to taken place like this.
Item 21, second appeal 85 of 2020.
Also, I seek an apology, Lordship, in item number 18, on behalf of State Person, could not appear.
कोई बात नहीं, आपका एजेंट
Lordship, only the later Advocate General could.
वो हमने कर सकते. आपका नॉन अपीयरेंस रिकॉर्डेड. यस, आर्ग्यू प्लीज.
The defendants are very upset. I order number 6 located 28 March 2023.
इसको ऑन पेज नंबर अच्छा इधर नीचे लगते हैं. आप डिफेंडेंट हैं?
Defendant,
कॉन्करेंट
respondent, appellant.
ठीक. It was a partition suit.
It was a partition suit. It was a partition suit. And Lordship, we kindly find order number 6 dated 28th of March 2023. That which brought this case was admitted and the substantial questions to all was having public.
Order number 6.
6.
Yes.
Whether the learned first appellate court of permitted publicity by misconstruing the Exhibit A not to be a family arrangement between the parties to the suit and their ancestors.
Exhibit A.
There was prior partition between the parties to the suit and their ancestors.
Exhibit A is a family arrangement.
Family arrangement.
What is the finding of the learned trial court in that connection?
Yes.
And where is that finding? What was the issue framed by the learned trial court with regard to Exhibit A?
The Supreme Court was current constitution.
Issue number 6. इशू नंबर 6 था ना?
जी।
तो बताइए कहाँ है फाइंडिंग ट्रायल कोर्ट का?
पेज 21 of the trial court judgment.
कहाँ से शुरू हो रहा है? इशू नंबर 6 कहाँ से शुरू हो रहा है सर? वहीं से पढ़िए। अच्छा, इशू नंबर 6 एक ही साथ लिया है, 4, 5 and 6. Where is the finding with regard to Exhibit A?
It's and they come to page 8.
Page 8. Yes.
Learner concept of the plaintiff, other contender, so far as defense witness is given H1 number. The defendant number 1 has not verified in his false explanation, which then has been allotted to him for what will be the partition. Also very important to mention here that the examination is stated in audit rule from Janama, either 24th May 78 or 24th 69. It means there was no audit from Janama, DT.21.07.2025 has not supported. The case of the defendant, the said document is not admissible in the contention. The said document is not admissible in the following ground. It is not a start document, nor the stamp registration of the solution. It is also a popular that which are just now in hand. It does not state as to which then was allotted to the defendant and which then were allotted to his court. Other than that, it is intention that any such unregistered and stamped partition to be notarization in evidence is not either here other before serving settlement publication before the settlement officer. So yeah, in the beginning of the solution, this defendant will also conclusion either it could be made on 24th to 69 or 24th to 78. According to his evidence in examination, the chief paragraph number 6 is made in 24th 69. In WS it is mentioned in the 4th 78. So it is disturbed. The document contained in the key because Mutaksara is too offensive, there is very strong assumption of law that the Hindu family exam in some of the cases becomes stronger when parties to the suit are women in this. Under the principle of law, they have been much higher than the case that the partition of schedule land took place on 24 In this regard, it is a select question that the defendant must create a fund as to which land of schedule A and B will in this case shown in the sale of the schedule land has been granted for the other new schedule that the partition on which settlements took place between the parties or between the various settlement issued published in August 1978 in the oral evidence review and community evidence categorically proved that this was a new partition.
This exhibit A has been believed by the court, trial court.
Yes, sir.
Where is that finding? Finding पढ़ी है ना sir?
Kindly come to page 21 of the time. Paragraph 21.
Yes.
After considering the entire material available, I find that the plaintiff in the plain, paragraph 7, listen and admit that the duty under an appellant separated the land by mutual consent and agreement in the law producing the suit land separately according to the choice of the
That's right. That is not partition.
Not a partition.
Let us proceed further. Because this court has already formulated the point of law on that point.
Exhibit A पर क्या finding है बताइए?
Exhibit यही पर आ रहे हैं ना, ये तो कमीशन चला है ना उसके बाद. Legal share of the plaintiff and defendant. In paragraph 8 of the plain, she further submitted that plot number 763 is bamboo clump and plot number 12 are ancestral plant property, which are still joint, but same has not been included in the plan to avoid the delay in disposal of partial partition. Disposal of the suit, and there are many procedures which could create embarrassment and voluminous recorded and plaintiffs describe the right for partition, if any, in future. It means thereby that the plaintiff filed this suit for partial partition. This could not have been filed. Partial partition, only the plot number 475 land of 4 dismissed. Thus, C6 partial partition from the entire case. There is no whisper of dispute at any place except plot number 475. She wants equal division of plot number 475, but it comes in evidence that she has got her share only 1 decimal in this plot, and also comes in evidence plaintiff's witness itself that the rest area 3 decimals of plot number 475. The Pakka house of the defendant number 1 has been constructed in which he along with his sons and other family members are residing. Every witness, even plaintiff or defendants, clearly admits that a partition of lands already taken place between common ancestors of both parties. Gauri Devi herself admits in cross-examination in paragraph 20 that Lakshman Mandal constructed his house in northern side of the village. Her father lived in the old ancestral house and she is also living there. Her father has constructed the new home too. In paragraph 24, she further admitted that Manjit was Bihar while having Badhya filed having 4 yaris, filled having 4 yaris, who cultivated herself and to her uncle. She further admitted in paragraph 25 that Tiltan is Dhani land and she cultivated land separately and her uncle plowed the northern side land. In part 28, she admitted that she bought 1 kattha land, whereas she should the half portion of land at the roadside. In part 34, C admits that plot guard number 475 in mud house was there, but her uncle forcibly constructed the pakka house there. Later on, in the same manner, other plaintiffs clearly admit partition taken place between both the parties. DW2, Kishore Pandey, stated in cross-examination paragraph 21 that both parties cultivate the land separately as per their convenience. In paragraph 25, DW2 stated Gauri living in the house of the Multi-Mandal. It is ancestral house. Gauri Devi, Multi-Mandal was the father of the Gauri Devi. Gauri Devi built a house nearby the ancestral house from the scheme of Indra. PW3 Municipal Company also admitted the decree of partition of dependent and stated in paragraph number 19 that the Multi-Mandal and Lakshman Mandal have two houses, both living separately. At that time, their mother was alive. Lakshman Mandal house in card number 475. Said house having mud and straw, and before him the second house mud and straw. It is plot number 460. The western side pakka house is plot number 475, which was constructed by Lakshman Mandal at about 2-3 years ago. In paragraph 20, PW3 further stated that at the time of separation, both brothers given 8 acres of land to their mother living with both brothers in some interval and mostly lived with Lakshman in the house. She died in the house of Lakshman in paragraph 21 of PW3 further stated both parties cultivation land are separately and on the account of no altercation taken place between both parties. Till the Lakshman Mandal and Multi-Mandal was alive, there was no quarrel. The
statement दिखाइए.
It is further admit that Gauri Devi has constructed a house under Indra Awas Yojana. With the Mr. Devi, during cross-examination, she stated in paragraph 19 that Gauri Devi living in an ancestral house and she constructed a house nearby with ancestral house. Lakshman Mandal built the house before construction of Indra and leaving his house, new house. Lakshman Mandal and Gauri Devi cultivated the land separately. In paragraph 26 of further stated living in new house in his lifetime of his mother. PW so Nundam Mandal has stated in during cross-examination part 4 that at the time of his mother separately. His father-in-law has two horses. He and his wife, Lanti, is the husband of Gauri Devi. His wife Lanti living in the old house, whereas his uncle father-in-law living in new house. In paragraph 6 of his wife further stated that his wife bought a house under the scheme of Indra Awas. And his uncle father-in-law also bought a house under the same scheme in the same house. In paragraph 8 of further admit that you now cultivate the same land from his father-in-law, cultivate the five other admit in part 4 of cross-examination that the agricultural land of which we have also half and half cultivated as well their convenience. PW6 so with cross-examination. Here the stated in class 7 that Secretary also given several receipts to Lakshman Mandal linked to the, he is the Pradhan of the Lakshman Mandal including Gauri Devi, he taken half hand from Lakshman Mandal, half from Yuvati Mandal. now I would like to discuss the findings of use of the plaintiff execution the solely for solution. The court's orders are there was, and after considering the requisite document produced by the plaintiff, it appears that the learned counsel of the plaintiff has strongly contended and rely upon Exhibit 4 and Exhibit 5 and 4 CC of the entire order of chief of the verification so as per the learned counsel of the plaintiff argument. Exhibit 4 is most important and the determinating of the document. So this is the plaintiff. Such an extending starting illegal construction over plot number 475 as of the plaintiff filed the rule in this case number 24 and after due recovery, learners no found body when in and joined and directed this petitioner to proceed beyond into this competency, not without it was a bad sir. Can you come to thus, I find enough merit in the contention of the legal counsel of the defendant is that from all problems, there is no dispute or difference that plaintiff does not cultivate the land as her father used to cultivate and she is residing in the same house in which her father resided. She has raised the dispute only in plot number 475. In which the defendant number 1 has got in his favor 3 disputes over which constructed not a good house and thereafter constructed a patta house.
Exhibit
I further find fourth is argument of the that plaintiff seek partial partition. Or there could have been a partial partition. And this has also been accepted by the lower appellate court. That earlier partition had taken place. From entire case, there is no whisper of dispute at any place except plot number 475. She wants equal division of plot number 475 when she has got her share only 1 decimal in this plot. From the rest area, 3 decimals of plot number 475, the patta house of the defendant number 1 has been constructed. After this house was constructed by defendant number 1 alone, she at the instance of her husband, she filed the suit for partition of the house in fact. When it was the house constructed by the defendant at their own cost. He along with his sons and family members are residing. There is no possibility of demolishing the house and to divide it again with Bhuti Mandal and Lakshman Mandal amicably partition. दो भाई में जब ऑलरेडी बंटवारा हो गया था तो फिर ये बेटी और बेटी का दामाद हस्बैंड वो आकर के ये ऑब्जेक्शन कर
एग्जिबिट ए में किसके किसके बीच बंटवारा हुआ?
मैं देख लिया
एग्जिबिट ए पढ़िए। Whether 2-3 चीजें हैं उसमें, whether the document itself is partitioning the property and whether there is actual partition or not. पढ़िए, exhibit A पढ़िए। Is it a memorandum of earlier partition or this itself?
It's in fact a family arrangement memorandum.
Family arrangement, sir. अगर मान लीजिए किसी पंचनामा से
It's not a partition.
Sir,
It's not
just a
legal
moment.
partition.
अगर किसी document से partition हो रहा है, then it is required to be registered. If it is only a memorandum, then it is not required.
It's only a memorandum.
Let us
Exactly.
read it, please. पढ़िए, पढ़िए, पढ़िए. Top से पढ़िए इसको.
आज तारीख 24/5/78 को एक बैठक मुसम्मा महेश्वरी देवी जोजे मुदो मंडल, गांव ककनिया, थाना सरैया हाट, वाले के घर पर हुआ, जिसमें मुनेश्वरी देवी के 2 पुत्र विभूति मंडल वो लक्ष्मण मंडल के बीच पैतृक जमीन को मकान का बंटवारा किया गया। मुदा ककनिया के जमाबंदी नंबर 30 के अंदर अपने कुछ इसका राइटिंग ऐसा है कि अपने इख्तियारी आधा आधा जमीन का बंटवारा दोनों भाई को आधा आधा दिया तथा साबित मकान जिसका दाग नंबर 464 रकवा 2 डिसमिल है, इस मकान को पुतनी मंडल को विभूति मंडल को दिया गया। दाग नंबर 475 रकवा 3 डिसमिल को अंदर 1 डिसमिल जमीन पीछे तरफ विभूति मंडल को दिया गया। बाकी 3 डिसमिल जमीन रोड के सामने लक्ष्मण मंडल को दिया गया। इस 30 डिसमिल जमीन को 40 लक्ष्मण मंडल अपने खर्च जो मकान बनाकर बसोबास करेंगे। मां मुनीश्वरी देवी को जीवन यापन के लिए कन्या पूजा के
This document is itself creating a partition.
Lord,
This is not a memorandum.
it's a memorandum. This is the exhibit A. And this
It's not
is
a memorandum.
This is not a deed of partition. My submission is that Lord, this was done. Your Lordship will kindly see the heading. It is Panchanama. It was done in presence of the Panches. It was a family arrangement with the agreement of the 3 persons, the mother and her 2 sons, Vibhuti Mandal and Lakshman Mandal, with respect to the residential properties. And 8 kathas were land of the land were given to the mother for her lord's maintenance.
Vibhuti Mandal and
Lakshman Mandal, both sons of Udo Mandal, of village Kakani.
and a portion was given to the mother.
And
Who filed the suit?
Daughter of Vibhuti Mandal, namely Gauriji, she has filed the suit. It has come, law, whatever I have read for your lordship, I can see.
This was all ancestral property.
It was ancestral.
So daughter was born when this particular.
Certainly, she was there. She was there.
She is not a party to this.
But therefore, Vibhuti Mandal and Lakshman Mandal.
She is not a party to this.
Let me complete.
Is she a party to this?
No.
Is she a party to this Panchanama?
No, she is not, because the agreement, the Panchanama was between the 3 persons, mother, the 2 sons.
That's right.
Even the
How
son,
this Panchanama will bind the daughter?
no,
How this Panchanama would bind the daughter?
certainly,
How?
because her father had already entered into.
Maybe father, she is a co-partner to the property.
She was co-partner. It is not before the year 2000. It is
Even
before
that,
the year 2005.
it has been held by Supreme Court.
It is held by the Supreme Court after the Lord that 2005 Succession Act, Hindu Succession Act, came into force.
No. She acquires the status of co-partner prior to that also.
Maybe, but she was a married lady. She was a married lady.
Married lady is excluded.
She could have Lord the ancestral property which is left behind by the father.
No, not by the father, by her ancestors. Ancestral property
yes.
left behind by her ancestors,
By her
not by her
ancestors.
father.
By her ancestors.
This is a co-pastory property.
Certainly it is co-pastoral property. Therefore, this Panchanama speech, this was agreed between the parties, is the family arrangement in presence of the Panchas. Panchas have endorsed to it. The parties who had blood with their blood in the Panchas, in that blood arrangement, they had already supported this fact. That is what agreed upon. And there could not have been partial partition. This court had, the trial court has said so. It was a partial partition. The partial partition cannot be sought for. The second Lord, the Honorable Supreme Court, and even this Honorable Court in a recent decision, Lord has come to him after discussing the decisions of the Honorable Supreme Court, etc. There cannot be a partial partition.
Which is that judgment?
Your judgments are 1994 SCC Volume 4.
Volume 4 SCC. पेज नंबर बताइए.
Just. ये डॉक्यूमेंट है जो आया है जिसमें ये सब सारा डिसीजन कंसिडर हुआ है. ऐसे नंबर 92 और 5 में आया है.
ये 94 का जजमेंट का आधा ही साइटेशन बताएं, इसको कंप्लीट कर दीजिए. पेज नंबर बताइए. 94
जस्ट वन बाय वन हम आपको
आप इस केस को मेंशन कर रहे थे ना, तो कम से कम कोर्ट के लिए तो जजमेंट एक कॉपी होना चाहिए. You wanted this matter to be taken up out of
अभी लाइब्रेरी से अभी हमको मिला. हमारे यहाँ घर में
मेंशन करने के पहले कोई तैयारी थी?
हम दे देंगे.
कब देंगे? लिखाएंगे हम अभी.
हम के सामने किताब देंगे.
कौन सा पैराग्राफ है? पेज नंबर भी नहीं बता रहे हैं. वो भी सीक्रेट.
I am not that fast.
पेज नंबर बताइए सर. पेज नंबर बताने के लिए व्हाट आई एम बियरिंग विथ यू. यू गिव मी द पेज नंबर. हम खुद मंगा लेंगे अपनी किताब. आपने तो लिस्ट ऑफ बुक्स भी नहीं दी है. लिस्ट ऑफ बुक्स की दिए हैं ना कुछ.
Why you are getting impatient?
No, it is not a matter of being impatient. You are supposed to give the list of books prior to the hearing.
Certainly.
हाँ, so
ये चीज. दस सिखोगे बार-बार करते हैं ना.
पेज नंबर बताइए.
294.
किताब मंगाइए.
This party's name is
94
H.A. Gowda. This is by legal name Siddhe Gowda.
और ऐसे नंबर कौन सा बोलूं?
ऐसे नंबर 92 of 2005. इसका और कॉपी करता है.
जजमेंट का डेट बताइए.
जजमेंट का डेट है 10 12th of September 2023.
इसका प्रिंट निकालिए. हमारे लिए लाए हैं? नहीं लाए.
ऐसे नंबर 92
सर के पास कॉपी होगा. कोर्ट के लिए कॉपी है?
दे रहे हैं. कोटे को दे रहे हैं.
पैराग्राफ नंबर इसमें कौन सा है?
अभी हमको तुरंत निकालना है. हमको रेफरेंस मिला, हम निकाले और देख लेंगे उसका नहीं है.
आपके पास नहीं है कॉपी?
नहीं, हम
वापस कर दीजिए. हमारे लिए निकालिए.
हम निकाल के
ये वाला निकाल दीजिए. ऐसे 92,000.
पैराग्राफ 16 में हम fully incorrect to assumption made by the High Court that Court of First Appeal had not accepted the case of partition. What has been held in the first appellate court was that the property has been allotted in favor of the first defendant in the partition. That is very different from holding that the case of partition has not been accepted by the first appeal. This being so, the degree of partition could not have been passed in mere application of the cause of action is different. This was the case of the even otherwise, a suit for partial partition, for partial partition in the absence of inclusion of joint family properties and the implement of other procedures was not warranted in law. Therefore, the judgment and degree of childhood as affirmed by the Paragraph 15 and 16 of this judgment. Paragraph 15 and 16 of this judgment. Yes, sir. Paragraph 15 and 16. Yes, sir. Paragraph 15 and 16.
ये तो हम प्रिंट निकाल लिए सर, ना थोड़े सोचते हैं आएगा मेरे पास ऑब्वियसली। 15 and 16 से क्या आप बोलना चाहते हैं?
पार्शियल पार्टीशन नहीं होगा, जब भी होगा तो पार्टीशन जब भी होगा तो उसमें सारे प्रॉपर्टीज को जो है उसमें इंक्लूड किया जाएगा जो ज्वाइंट फैमिली, नॉट इन एक एक को कर दिया और उसको छोड़ दिया, इसमें यही हुआ। इट हैज बीन द स्पेसिफिक फाइंडिंग ऑफ द ट्रायल। और वो एपेलेट कोर्ट जो है उसको डीड को पार्टीशन को वो कहता है कि इन द एब्सेंस ऑफ नॉट बीइंग रजिस्टर्ड इट्स नॉट ए पार्टीशन। यही एपेलेट कोर्ट कहता है। वो इसको फॉर्ज और मैन्युफैक्चर डॉक्यूमेंट नहीं मानता है। एपेलेट कोर्ट से ये कहता है कि इसको जो है सो इसमें भी ये 2017 का वॉल्यूम 11 SCC पेज 548 इसमें यही कहता है, कहा गया है केस वाज रिमांडेड फॉर इंक्लूडिंग ऑल द प्रॉपर्टीज इन द एज सूट। this judgment was this will report to her. Substantial question of law has been formulated with that.
The relief was paid for partition of the entire Schedule A property. That was the relief.
But the appellate court has also confined to it only with respect to a.
आप तो रिलीफ देखिए ना, सूट में क्या रिलीफ था, इसीलिए ना सेकंड अपील सुन रहे हैं. कहीं कुछ गलती हुआ है उससे कुछ सुन रहे हैं. सूट में देखिए, the suit was for partition of the entire Schedule A property.
Just from those judgment.
डिक्री ना देखें हम लोग.
Confined to only with
डिक्री नहीं
respect
देखें.
to 475.
डिक्री पढ़िए ना सर. ऐसे कन्फाइन करने से थोड़ी होता. डिक्री ये बस फॉर द सूट वाज फॉर द पार्टीशन ऑफ द एंटायर प्रॉपर्टी. He claimed half share. Trial court gave a finding that there was already a previous partition.
जी. Let's
In
see
the year 1960.
of the lower appellate.
The appellate court says that it is not a document of partition.
Since it was not a register.
There are other reasons also. Para 26 of the appellate court.
PG. I am also.
There are many other reasons.
Partition to demand from Panchanama dated 28/5/1978 executed as a on perusal of the said document. It appears that the same has been written on a plain paper. Obviously, it is on a plain paper, on which some signature of thumb impression are available. As per the said document, on 24/5/1978, a panchayat was convened in the house of the Ministry for partition of ancestral property between both sons of the Evidentiary, namely Niti Mandal and the son. The said panchayat, both the brothers were given half portion, each in Mila Kakani, into number 30. Niti Mandal was given the house standing plot number so and so, and out of the dismals of it, one dismals in back side was given to him, and remaining 2-3 dismals in both sides is given to Lakshman. Constructing his house, Mother Evidentiary Devi was given 8 katha land for her maintenance. And after the death of said man, after the after her death, the said land will also be partitioned between both the families. The recital of the document in question goes to show that the document is not a document of not a document of partition. It is only an amicable arrangement. Certainly, it is not an amicable partition. We never asserted that it was a partition. It is simply a panchanama for family arrangement. It is only an amicable arrangement between the parties for their convenience. The document does not contain plot common area of land which have been allotted to both the parties and their mother. Though the document says after the death of mother, both the brothers could make partition of the land possessed by her. How much land and in which portion of the brother will get has not been mentioned. In such position, it is clear that the document is not a document of the memorandum of partition. It seems that the lower court have wrongly misinterpreted the document as a document of partition. It is not a document of partition, I have asserted. It is not a deed of partition, it is not a document of partition. It is simple deed of my lord's memorandum of family arrangement.
The court has said that it is an arrangement for convenience.
And this was in fact acted
The court
upon.
has said that it is a deed of convenience. It is just a deed of convenience. It is not by means and compound, and the document does not even disclose as to how much area has been allocated to whom. Nothing has been
It is
mentioned.
clear that the document is not a document of memorandum of
That's it.
partition.
आधा sentence मत पढ़िए, उसके बाद वाला sentence पढ़िए.
It seems the learned lower court have
It only made an amicable arrangement between the parties for their convenience. Therefore, it is not a document of partition.
Certainly, it is not a deed. I never said it.
Nor it is a memorandum of partition.
It is a memorandum of arrangement of family arrangement. Family arrangement is something else than the deed of partition. If it is a deed of partition, it is required to be registered. Certainly, if it is a deed of partition, then it is required to be registered. It is not a deed of partition. It is not a memorandum of partition. Okay. Because even the Honorable Supreme Court, the decision your lordship will kindly accept, the proposition, it is not a decision of the Honorable Supreme Court, reported in 2020, volume 3, JBCJ. Page 455. Party's name is
2020 volume 3 JBCJ.
page 455. Ravinder Kaur Dewal, appellant versus Manjeet Kaur. Property law, family settlement. Object of such arrangement is to protect family from long-drawn litigation or perpetual strife, which mar unity and solidarity of family and creates hatred and bad blood between the various members of the family, when by virtue of family settlement arrangement, members of the family descending from common ancestor or a near relation seek their differences and disputes, settle and resolve their conflicting claims or dispute titles once and for all in order to buy peace and in mind and bring about complete harmony and goodwill in family. Such arrangement ought to be governed by special equity peculiar to them and could be enforced if honestly made. And registration is not at all required, it has also been said. Therefore, Lord, in my humble submission, this was simply a memorandum of partition, memorandum of family arrangement, settlement, and there is no question of its being family partition. It's not a family partition. And by virtue of this family arrangement contained in Annex A, as you lordship has seen, that this property, this was the Lord settlement was made, and it has also come, there was no unity of title ever. Thereafter, this 1978 family arrangement, which is by virtue of a with Panchanama, this document exhibit A, the Lord, it was also acted upon, and only thereafter, Lord, the vacant portion of land which was allotted to Lakshman Mandal, he had constructed a pakka house.
Mutation was done?
It's a Pradhani Moja, there is no question of mutation. In Pradhani Moja, there is no question of mutation. Pradhan has a
Rent must be paid to the
yes, he's paying rent to the
rent to the portion which was allocated, or it was paid for the entire portion?
It is a just Lord homestead land, and there is no dispute with
That's
regard
right.
to that.
After maybe that after all rent will be paid, isn't it?
Certainly.
So rent receipt was only in connection with part portion of the entire property, or it was with
It
respect
has
to the
come in
entire?
the evidence. The Lakshman Mandal or Vibhuti Mandal दोनों आधा दे रहे थे. It has come in the evidence. Your Lordship has seen it. दोनों अपना दे रहे थे. Evidence में आया है कि दोनों आधा दे रहे थे.
Where is that
Even
finding?
the प्रधान ने
Where is that finding?
उसके बारे में तो appellate
Finding
finding नहीं है.
Trial court का finding दिखा.
मतलब ध्यान को तो फाइंडिंग पेज 24 पैराग्राफ 24 पेज 24 में है.
पढ़ी?
Thus I find that merit in contention in the
नहीं नहीं उससे
contention
पहले
of
पढ़िए ना. हमको ये रेंट रिसीट के बारे में बताइए.
जी,
कहाँ है?
उसके बारे में आया है कि वो भी दे रहा है, हम भी दे रहे हैं.
दोनों का पूरा का दे रहे हैं.
दोनों दे रहे हैं.
अपना अपना कहाँ आया है? वही दिख रहा है.
और सब जमीन का भी दे रहा है.
पैराग्राफ 23 पैराग्राफ 23. दिखाइए एग्जिबिट 6.
ट्रायल कोर्ट का जो जजमेंट ये आ गया है कि वो दोनों 78 के बाद जो है पैराग्राफ 30 में कि दोनों अपने अपने पोजीशन में हैं और हम इस पोजीशन में हैं. ये पैराग्राफ 30 में है ट्रायल. इस पे पेज 23 पर है हुजूर. पेज 23 पैराग्राफ 23 में है. Now I would like to discuss the documents adduced by the plaintiffs. Exhibit 1, CC of order so and so, so and so, so and so. CC of Court of Exhibit 6 to 66. Yeah, Exhibit 6 to 66 are Pradhani rent receipts of Javamandi number 30 of Moja Kakani.
30 is the entire land.
Kakaniya, Moja Kakaniya.
30 is the entire land.
Have been filing the following documents for proof the Exhibit A Panchanama B2 B6 rent receipts of Javamandi number 30 of Kakaniya. दोनों दे रहा है. आधा दे रहा है.
आधा आधा कहाँ से बोल रहे हैं आप बताइए. आधा आधा दे रहे हैं तो बताइए कहाँ से बोल रहे हैं.
ऐसा ही जो एविडेंस में जरा सा आया है. एविडेंस Yes, I would request your Lordship to kindly see the deposition of PW.
सर आप बताइए ना, एग्जिबिट के आप बोल रहे हैं दोनों आधा आधा दे रहे थे, तो उसका फाइंडिंग का
उसी के एविडेंस में आया है, जरा सेकंड PW 6 का एविडेंस में लास्ट ये पैराग्राफ 8 से देखा जाए 9 से 8 से देखा जाए एविडेंस में शंका का समाधान होना जरूरी है। आपको जो जो किताब आप साइट करना चाहते हैं आप उसका साइटेशन अभी दे दीजिए। अपने पास रख के कोई किताब मत पढ़िएगा, हम नहीं पढ़ना। अपने पास किताब रख के कोई भी जजमेंट पढ़ेंगे तो हम कैसे पढ़ेंगे? I'm sorry.
Absurd है ना ये?
I'm sorry, I understand.
इसलिए आप जो हैं
I own the responsibility.
तो इसीलिए जो भी अपना किताब का लिस्ट
हो उसमें दे दिया जाना चाहिए।
तो भाई आप अभी प्रोवाइड कर दीजिए वो लिस्ट, जिससे कि सेकंड हाफ में हमारे पास सारे बुक्स आ जाएं।
ठीक।